Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 74 of the NCDWI Guy podcast. We're on the DMV train. September, we're on the DMV train. It's the DMV month. So we've already talked on episode 72 about refusal hearings. Last week on episode 73, we talked about DWI restoration hearings following a suspension. And now we are talking about ignition interlock violation hearings. So that's what we're going to be focusing on today, ignition interlock violation hearings. Before we dive into today's episode, it is Childhood Cancer Awareness Month. As a firm, we are trying to raise monies for St. Jude Children's Hospital in Tennessee. St. Jude's does research on cancer for all types of different cancer that impacts children. Every child patient at St. Jude never receives a bill, nor do their families, for staying at St. Jude's hospital and all of the services that their kids are getting. So an incredible organization. September is Childhood Cancer Awareness Month. We are trying to raise $30,000 for St. Jude Children's Hospital. We have been able as a firm to raise, as of this date, about $25,000. We have gotten other people through our Facebook page to donate close to another $1,000. So help us hit our goal. Help St. Jude do what it does, which is to help kids that have cancer and their families. You can go to our Facebook page, the Minnick Law Facebook page. You can go to my personal page on Facebook. And please, if you have $5, $10, $20 to donate to St. Jude's, it would be much appreciated. We're looking forward to being able to do what we can to help in the fight of childhood cancer. So I appreciate that. Moving into today's topic, we again are talking about ignition interlock violation hearings. And so we're going to go through this kind of methodically in terms of when do you need to start talking to your client about an ignition interlock hearing? What's the evidence you should go look at? What is going to happen at the hearing itself? So to begin the conversation, what we're going to do is start out by looking at when is an ignition interlock device required on a person's vehicle following license restoration, and secondly, for how long. So under 20-17.8, that is the statute that we look to in terms of the times when an ignition interlock device is going to be required as part of a restoration. So first and most common is under 20-17.8A1. It's going to be required if there is a 0.15 or higher alcohol concentration. So that's going to be the most common time frame. You can get credit towards the required period of ignition interlock under 20-17.8A1 through a ignition interlock limited driving privilege that is giving credit before the license is actually restored. So just so you keep that in mind, you can get that credit through the use of a limited privilege. But the first situation where a ignition interlock device is going to be required is under 20-17.8A1. And secondly, under 20-17.8A2, the person has been convicted of another DWI 7 years prior to the date of offense of the charge for which the license is being revoked. So you have a 7-year look back period. If there is a conviction within that 7-year look back period, even if the person blew a 0.08 on the second one or a 0.14 on the second one because of the fact that they had that prior within 7. Now they're going to have a ignition interlock device. And this ignition interlock device is currently required regardless of whether alcohol was even involved in the actual DWI charges themselves. So to just give a quick example of this, I have had clients in the past who had to have an ignition interlock device on their car for a 3-year period or a 7-year period following the reinstatement of the license, even though the charges that they were convicted for, the DWI charges that they were convicted for, did not involve alcohol. They were drug, other impairing substance charges. So it doesn't matter, again, whether it was a 0.15, if you've got 2 offenses and that's causing that period of revocation, doesn't matter if it was a 0.15 or even if alcohol was involved. If there's a prior DWI conviction within 7 years of the date of the new charge for which the license is being revoked, you're going to have the ignition interlock, even if the underlying substance was an alcohol. So again, 0.15 or prior conviction within 7 years of new date of offense, that's when you're going to have the ignition interlock. Now the question becomes, for how long? So the length of the ignition interlock requirement is found under 20-17.8C. And what 20-17.8C says is that the ignition interlock is going to be required for 1 year if the original revocation was for 1 year. It's going to be a 3-year requirement if the original period of revocation was 4 years, and it's going to be a 7-year period of ignition interlock required if there is a permanent revocation. So 1 year if the original revocation period was 1 year, 3 years if the original revocation period was 4 years, 7 years of ignition interlock if the original revocation was a permanent revocation. So that is what you look to in terms of determining how long the ignition interlock is going to be required. What you want to be able to do when you're preparing for a hearing to have somebody's license restored, again, we talked about that last time, but if you're going in on a permanent revocation hearing, one of the things you want to advise your client as they are preparing for their permanent revocation hearing is, if you're planning on living in North Carolina, you're going to have a 7-year period of ignition interlock following the time frame that your license is restored. Don't let that be a surprise to kind of undo all the good work that you did in your restoration hearing, getting your client's license restored. They're cheering, they're high-fiving their family members and friends that have come and acted as witnesses. And now the hearing officer is going through, okay, here are the conditions of restoration. One of those is going to be a 7-year requirement of ignition interlock. You want to make sure that they're prepared for that. And that's not the first time that they are getting news of this requirement. So that is when the ignition interlock is required, and for how long it is required. Look to 20-17.8 to get those questions answered. So in terms of preparing your client for an ignition interlock hearing, again, when do you do that? Well, at the point that you get somebody a ignition interlock limited privilege, or at the point that a client is going in and getting their license restored and you're helping through that process, make sure you talk to them about how to avoid any ignition interlock violations. And the main thing that I say is that if you go to Monotech, if you go to Smart Start, you go to Alkalock to get your ignition interlock device installed, talk to them thoroughly about the types of contaminants that can cause a false positive on this device. Make sure that you are aware from the installer how this could impact things that you're putting in your mouth, things that you have in your car, how that could impact the readings on the device itself. Make sure you go thoroughly through that with them. Then I tell them, make sure you keep a notepad or use the Notes app on your phone to record any oddities that are given to you after you blow on the ignition interlock device. So before you do anything else, if you get an error message, something comes up on your ignition interlock device in terms of a reading, make sure that you are getting that information recorded, explaining what's happening, where you were driving, what was going on with the device, what you think might be the cause in terms of a false contaminant. Make sure that you have worked through that process, because if you've worked through that process with them, they're going to be much better prepared down the road when they get notice of hearing, which I'll talk about in just a minute, the kind of lengthy time frame of waiting for that. And then finally, you want to make sure that you tell them to have a bottle of water in the car with them so that they can wash their mouth out before every single time that they blow. Make sure that you advise them of that. The company's going to tell them that, whatever installer they go to, they're going to tell them to rinse their mouth out with water before any ignition interlock reading, before they actually give a sample in that ignition interlock device. But emphasize that, because there's going to be questions both from the hearing officer down the road, and you probably save your client some trouble if they follow that advice and actually do rinse out well with water before any time that they blow into the device. So that's what you want to do in terms of preparing your client, how to kind of best use or document anything that is coming from the ignition interlock device itself. So if there is a ignition interlock violation, person is driving down the road, they get a notification on their device that there is a alcohol reading present, and that they basically are going to have to do a rolling retest again in just a couple of minutes. The first thing that they're going to be thinking is, is this going to cause a violation for my license? Am I going to get a notice from the DMV about this? The DMV gets all of the logs from the various providers, and then they do basically a quick run through of anything that they see as a potential topical violation. So if they can identify, if the DMV can identify that there is a topical violation, then you kind of by their own screening process, they will not issue a violation for that. If they can identify, it's not clear what the basis for the violation was, then they will send a letter to your client indicating, we have received notice from your interlock provider that there was a alcohol reading. Your license is going to be revoked unless you request a hearing. So it's a automatic suspension of the license in that case, unless the person requests a hearing to present evidence on that issue. In order to request that hearing, the person would need to fill out a form that we've talked about over the last couple of episodes, driving license hearing request form HF-001, which is a DMV form, and you're asking for a preliminary hearing on a alcohol concentration restriction violation. So it's a $450 hearing request. That hearing fee can be waived for somebody that is indigent, but it's that preliminary hearing, ignition interlock device restriction violation. I think it's the fourth box down on the form that shows revised on September of 2018. So that's again, form HF-001, fourth box down, preliminary hearing ignition interlock device restriction violation. So you send that hearing request in saying, I would like to have a hearing on this violation. And then a hearing date is set. Now, the notice letter that is received from the DMV that says there was a ignition interlock device restriction violation, license is scheduled to be suspended, does not give a date of the violation on that letter. So the person that receives the letter has no idea, based on that notice letter from the DMV, as to what specific date is in question. And the frustrating part on that front is that many of the actual violations occurred months before client ever gets that letter from the DMV. So I've had clients that, have gone 6-8 months before they get a letter from the DMV stating your license is going to be suspended because of an ignition interlock restriction violation. And so they're kind of scrambling at the point that they figure out when that violation date is, about how to collect evidence on that, because it's something that happened months before. So that's why telling your client to document any error message that they're getting, or any alcohol being present message that they're getting from the time that happens, immediately documenting that. Because if there is a hearing violation that is scheduled related to that specific event, it may not get scheduled for months down the road. They may not even get notice of it for months down the road. And that's going to be many more months before there's an actual hearing that is scheduled. So on that initial notice letter from the DMV, basically no information is communicated about the specific date of the violation. So how do you get that figured out? How do you figure out when the actual violation occurred? What specific date are we looking at? Well, as soon as you or your client have requested a hearing on the ignition interlock device violation, as soon as you've requested that hearing, you want to reach out to the hearing officer that covers the counties in which you practice, and basically ask the hearing officer, what specific date or dates are we looking at? Again, you're not going to have that on the notice letter. You want to make sure that you're preparing to address the right dates ultimately at the hearing. So you have to reach out to the hearing officer and ask the hearing officer to let you know which dates are in question. Hearing officers, I've dealt with multiple hearing officers on this front. They've all communicated that information without any issue. So it's not something that you have to, think how you can get this. Most of the hearing officers are very easy to work with and helpful in terms of getting that information back. So reach out to the hearing officer that would be involved and ask them which dates are in question. The next most important thing is that you want to get a copy of the logs. You want to get a copy of any of the logs from your client's interlock provider. And this can be kind of a grueling process. I always ask my clients to request this, and then I request it myself. But there have been many issues trying to get these logs back. So you want to give yourself as much time as possible getting these logs back, so that you don't get to the hearing date and don't have the logs received. So you want logs that would show the entirety of the time that the ignition interlock device has been on the car. And typically these logs go for about 2 months at a time. There's a new log generated basically anytime the vehicle is taken in to be serviced. You have to get the vehicle serviced at least every couple of months. So normally you see about a 2-month period of time being reported on these logs, but it can be different, can be a lesser amount of time if for some reason the device had to go in and get serviced before that 2-month time frame. So you might see 6 or 8 different logs. If your client has had the ignition interlock device on for close to a year, you're going to see multiple logs that are coming in related to the different times that the vehicle has been serviced. Most specifically, you want the log involved in terms of the specific violation date that is going to be at question in the hearing. So there should be a detailed log that you can request that would show all of the timestamps for the specific date that is in question. So you want a detailed copy of the log, not just the summary page that explains how many violations occurred during the reported dates, how many times the breath was actually collected. You want the detailed log that shows the minute and second timestamp of what was going on on the specific date that your client is being reported to have violated the ignition interlock restriction. So you want to get a specific copy of the log. Then you want to request as much information from your client as possible once you've narrowed down the date. So don't do this during the consultation. When your client calls in freaking out saying, I've got a violation. I haven't drank alcohol the whole time I've been driving my car, or I know that I never get into my vehicle with any amount of alcohol in my system. This has got to be a mistake. Don't start asking at that point which date might be in question, because even as much as a client might think that they know which date is in question, you do not guess about that. You contact the DMV hearing officer first. Once the DMV hearing officer confirms which date that is in question, you go back to your client and say, this is the date that we're looking at. This is what the hearing officer has told us. Let's look at the specifics of this particular date. Tell me what you remember. What were you doing? What happened at the time that did you take any notes? If this was, a Tuesday back in February, were you working that day? What was going on? So you're trying to get as much information as you can from the client about what they remember about the specifics of the date that is going to be the main issue, the main date at the hearing. So get as much information as possible. And sometimes, unfortunately, there is zero information. They might say, this happened 8 months ago, on a Friday, midday. I have no idea. I don't remember anything about that specific date. I didn't write anything down. I didn't, think anything of this. I've had some, odd error messages on my ignition interlock device in the past, but I never really kind of thought twice about it. So I've had clients that really just, this is out of the blue. This letter from the DMV is out of the blue. So make sure that you communicate only the date that is in question in terms of trying to get that specific information, because that's what you're trying to get prepared for on the hearing. This is the specific date that the hearing officer is going to be asking your client about. So get as much information from your client as possible, and then finally try to determine, is there any witnesses that might be helpful at the hearing, either because they can speak to how your client generally operates the ignition interlock device, or because they were actually involved in some capacity that day. So maybe somebody always drives with another person back and forth to job sites. They always have somebody else in the car. So now that witness could speak as to what they were seeing on that specific day. Maybe you have a roommate who regularly sees the person drive, can communicate, well, I live with this person. I've never seen this person ask somebody else to blow into the device for them. I've never been asked by this individual to blow in the device. So whatever the circumstances are in terms of your defense presented at the hearing as to why this is a topical violation, why this should not be considered to be an alcohol-related event causing revocation, try to identify those witnesses. So again, in preparation, you want to call the DMV hearing officer and get the specific dates involved. Order a copy of the logs from the specific installer. Have your client do the same. Get as much information from your client as possible about the date in question, and then finally determine any witnesses. So that is basically what you're looking at in terms of the process for initial information getting collected so you can prepare for the hearing. So in terms of preparing your client for the actual hearing, so now DMV has issued notice of a violation and pending suspension. You or client have requested a hearing. DMV sends a letter stating your hearing request has been received. The date of the hearing is X, let's say December the 15th, at the DMV located on whatever location it is across the state. So they send that notice of hearing. So what is going to happen at that hearing? Well, the hearing officer, as you go into the room with your client, so you and your client go into the hearing room to talk about the ignition interlock violation. The hearing officer is first going to put who is present at the hearing, what the hearing is in regard to, and explain that the hearing is being recorded. So it's a recorded hearing. Prepare your client for that. Testimony is that is received under oath. So the hearing officer would then swear your client to the tell the truth, and then begin asking questions of your client. And typically, where they're going to start is, this is an ignition interlock hearing based on a violation that occurred on February the 28th of this year, approximately 9 o'clock in the morning. Do you recall what was going on? Tell me what was going on that day. If your client and you have talked about what was going on that day, your client took notes or has memory about what was going on, then they're going to speak to that. If they don't remember, they're going to communicate to the DMV hearing officer that they don't recall what happened that day. And I always tell clients, when you're testifying under oath, tell the truth. That is, at the end of the day, the most important thing when it comes to a DMV hearing officer's perspective, is to make sure that they are looking at the person that's testifying and finding them to be a credible witness. Don't embellish anything. Don't tell things that you know not to be true. Tell the truth, and things will generally go well for you in the DMV hearing setting. So if a client doesn't remember, I just tell them it's okay if you don't know the answer to a question. Don't pretend to know the answer to a question. Don't make things up. If you know the answer, speak the truth and talk to the DMV hearing officer. So they're going to get asked questions about specifically what was going on at the time of the violation, and that's going to be kind of the initial focus point. Then the hearing officer is going to ask questions about the ignition interlock device. How long have you had it on the vehicle? Don't you know to rinse your mouth out with water? Are you aware of the different contaminants that can cause problems? Did your installer talk to you about these things? So, I've seen some hearing officers go a little bit more softball with these questions, and some hearing officers go much more full court press in terms of saying, well, you're telling me that you used hand sanitizer that day, but didn't you know that hand sanitizer contained alcohol? Didn't you, think of that on your own? Didn't your installer tell you that? So it depends on the kind of particular hearing officer, whether or not they're basically kind of trying to use this as a learning experience for your client, or if they're actually trying to kind of make a decision about whether or not alcohol was involved and there was some sort of violation. The best ignition interlock violation hearings, factually, the best factual hearings are where you have a person that has either a fail on a startup or a fail on a rolling retest, and then subsequently passes on another rolling retest, or a second rolling retest. So basically, before the device ever is turned off, before the car is ever turned off, the ignition is turned off, the person has already passed a rolling retest. That's pretty easy to explain to the hearing officer. This is a topical fail, because if you're that quickly able to pass a rolling retest, then it doesn't seem like alcohol is going to be the substance at issue. Again, if you're probably not going to pass a rolling retest if you blow a 0.08, at 4:56, when you're asked to blow again at 5 o'clock, 4 minutes later, you're likely not going to be at zero. So normally you see these kind of violations on a 0.01 to a 0.04. If there's a rolling retest that occurs that shows zeros within a very short period of time after the initial test, that's going to be the easiest thing in terms of presenting your case to the hearing officer at court. the log kind of speaks for itself on that front. So again, that's why the log can be so powerful, because there is great information that is packed into that log. You might see a violation that occurs at 4:52. Person pulls over, panics, turns off their car, doesn't know what they're supposed to do. Maybe they call the ignition interlock company and they're like, you should probably turn your car back on and blow again. 15 minutes later, car goes back on and there is a rolling retest passed. These are the kind of like pieces of information that you're looking for in those logs. And if you don't know how to interpret the log that you get back from the ignition interlock company, call the ignition interlock company and say, what does this code mean? What does this abbreviation mean on the log? I need to know what this specifically is communicating. Make sure that you understand what is going on, because there's a ton of information on that detailed log report. Make sure you understand that. Contact another attorney, contact somebody at our office, whether that's me or one of the other attorneys across the state. Contact us and talk to us about what is contained in the log, how to kind of best make sense of what was going on at the time of the alleged violation. So get some insight into what's going on at the time of the report. So the officer at the hearing is going to ask your client questions about what was going on the specific date. Then they're going to ask some questions generally about how the person uses the ignition interlock device. And then you'll have the opportunity to ask questions of your client. Maybe you do, maybe you don't ask very many questions. I have had certain times when the violation appeared on its face to be so clear that it was a topical issue, that this was not an alcohol related event. And that kind of became clear through the DMV hearing officer's testimony, that I have not asked questions. And sometimes even before the hearing, I'm going to tell my client there's a likelihood that I'm not going to ask any questions in this hearing. I'm there, mostly to prepare you for what's going to happen at the hearing, make sure that we have all of the correct information, and then to be there present in the hearing with you in case something goes sideways, in case, we get some information out of left field. But assuming that everything is as we expect it going into the hearing, I'm probably not going to ask any questions. So there have been times when I've communicated that, but it may be helpful to ask questions. It may be helpful to kind of clarify, what were you doing that day? Where were you driving to and from? How long have you had the ignition interlock device on? Have you ever had this same situation come up in the past? When was the last time that you consumed alcohol? You can bring out further pieces of information that the hearing officer may just either not question or may not get clarity on, that would be helpful. So be prepared to ask questions in the hearing. And then finally, in any situation where the hearing officer doesn't think that or it's not clear whether or not this is a topical violation to the hearing officer, you typically will get a closing argument to explain why you believe this is a topical violation. So I had a client that got a ignition interlock violation about probably 8 months into his required time frame of ignition interlock. He had to have it on for a year. He got it early in the morning. I think it was about 8:30 in the morning. He knew that he had been at a job site. He freaked out. He drove his car down to the bottom of a hill, hoping that maybe if he moved the location of the vehicle, that would clear things up. It didn't. He is just like sweating bullets and panicking. He's out supposed to be helping do a sealant on a concrete driveway, and came to find out that he had this giant can of sealant and paint thinners and all kinds of other paint products in the back of his car that caused an issue with this particular on this particular date with the violation. So we actually brought in the paint thinner into the DMV that he had used and the sealant that he had used. On the side of the paint sealer can, you could see the specific chemicals that kind of mimic ethanol in terms of how the device might read those things. So again, there may be certain situations where particular pieces of evidence or a witness. He had a employer that had been with him that basically came in and said, this person was working with me. I didn't notice anything unusual about him. He didn't appear impaired. Everything was as normal. He came in and, arrived on work, seemed like his normal self. So again, you may have witnesses or other pieces of evidence that you can present at the hearing outside of just being able to cross-examine your own client. And if you do have other valuable pieces of evidence, you want to make sure that you bring that to bear, because to have to lose your license and then ultimately down the road restart the required time frame for ignition interlock is a massive deal for your client. So you want to put your best foot forward, put as much information as you can in front of the hearing officer. If there is any relevant evidence to be shared, make sure that you share that evidence. So that's kind of what we would be looking at and expecting in the DMV hearing itself. Again, the best thing to do to prepare for an ignition interlock hearing is, number one, contact the DMV hearing officer and make sure that you're looking at the correct date. Make sure you know which date specifically is going to be discussed at the hearing. Second, get a copy of the logs. And then again, you want to get evidence, talk to your client about everything, but then get somebody else's eyes onto what you are going to present at the hearing. Talk to another attorney about how this is going to play out or how they expect it to play out in the local DMV. In every place, every county across the state, there is several attorneys that are regularly going in every county across the state, several attorneys that are going in and regularly handling these kind of cases at the DMV. Figure out who those people are, reach out to them and get somebody else's input, because this is a massive deal for your client. You want at the end of that hearing for the hearing officer to decide this was not a violation and the license is not going to be further suspended. So you want to make sure that you've done everything possible to keep this from further causing problems for your client. So I hope that information has been helpful to you, and I look forward to speaking with you next time. We've got 2 more DMV episodes for the rest of September scheduled. So keep the DMV hat on and we'll continue on the DMV warpath. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.